Hi, my name is Robert Chelle with Chelle Law, and my firm assists physicians with employment contract issues. Today, I'm going to talk about how a physician can terminate a contract with cause. So first, let's kind of talk about what is with cause and without cause. So first, without cause means a physician or employer can terminate a contract for any reason with a certain amount of notice. Generally, it's 60 to 90 days. Anything above that would be, I guess, kind of a red flag to me. But without cause just means either party can get out of the agreement for any reason with a certain amount of notice. So with cause termination means one of the parties, so the employer or the physician, has breached the contract in some way, and then the other party decides that that breach is grounds to terminate the contract immediately. So in most physician contracts, it will state the employer can terminate the physician for these reasons, and they'll list 20 different reasons. They obviously, the kind of practical ones, they lose their license, DEA registration, the physician is uninsurable, they get a felony. Then there's some more kind of like nexus reasons. They don't get along with their colleagues. They're not following employer policies. Many of them will just stick at the very end, or other good cause reasons, just kind of like an absolutely broad amount. I don't get too caught up on what it is or isn't in there. Obviously, you want to remove anything that's like absolutely, completely unfair. But the section for the physician's ability to terminate the contract with cause is either very small or non-existent. So if you do have a physician contract that has no ability, or at least no language for the physician to terminate the contract with cause, that is a red flag that needs to be looked at. Another thing that needs to be in the agreement is a cure period. So a cure period means if either party thinks the other party is in breach of contract, they have to let them know formally. So you have to send written notice to the other party that you believe they're in breach of contract, and then send it to, there'll be a notice section in every contract that says how and who you need to send any kind of written notice to. Follow that. And then at that point, there would be some kind of cure period, meaning usually it's between 15 to 30 days. And that just means if one party is breaching the contract, they have 15 to 30 days to fix whatever the breach is. And then if that is fixed, then the other party cannot terminate the contract for cause. So what's the benefit of terminating contract for cause? Well, one, it can be immediate termination. So in this case, as I said before, if there was like a 15-day cure period and the employer still hadn't fixed whatever the breach was, the physician could terminate the contract immediately and move on. Now, there are some complications when you're a physician that have to be thought about before you just terminate the contract with cause and move on. One, obviously it's specialty dependent, but there are some continuity of care issues that have to be taken into account in any physician setting. Now, if you're just doing shift work, so if you're in the ED, hospitalist, radiology, pathology, things like that, where you don't have like an established patient base, it's much easier to get out of the job quickly. If you're in primary care, cardiology, dermatology, where you have an existing patient base, psychiatry is like probably the absolute number one that has to worry about this. If you have an established patient base, there needs to be some kind of plan to move those patients to a new provider. If you were just to abruptly leave practice, there's been no notice to the patients. Maybe there's no one to replace the physician from the practice. There needs to be some kind of mechanism to move those patients on to a new provider there need to be some consideration into, if it's psychiatry, into some bridge scripts, so that the patient isn't just have no ability to get their psychiatric medications. It's generally in that case, it's a bad situation. It's very, very uncommon for a physician contract to be terminated by either party for cause. Most parties just don't want to deal with the kind of legal complications that come with for cause termination. If a contract is terminated, 95% of the time, it's going to be without cause, meaning they're just going to say, here's your 60 days notice. I'm leaving after this. I'm moving on. And in that case, 60 days is plenty of time to come up with some kind of plan to, for continuity of care for the patients, to move them on to someone else, but get the prescriptions in place. It's just a better situation. Whereas if there's an abrupt ending to to an employment agreement with a physician, it can cause all of those complications. I'd say one situation that comes up, fairly often, is a physician will call me and say, hey, Rob, the employer is not doing any of these things. They're not paying me on time. They're not providing me adequate support staff. Their volume expectations are crazy. It's been going on like this for 6 months. My first question is, did you let them know? Have you given them notice that they're not fulfilling their end of the contract? And most of the time the answer is, well, I've talked to them. Well, okay, that's great, but did you give them formal notice? Did you send them a written notice explaining the way that they're in breach of contract and that they need to fix it? Most of the time the answer to that is no. So that's the first step, is letting the employer know that they're in breach, and then hoping to fix those issues. That I say the trickiest situation is if, I guess it could be a variety of things. If the physician doesn't feel safe practicing in that practice, they have to consider, okay, well, what's the liability of actually staying here versus leaving abruptly? If obviously it's a terrible situation if a physician doesn't actually feel safe to practice, and that could be maybe lack of staffing. I found a lot of offices are having problems finding adequate support staff. So either MAs or nurses or even an office manager, receptionist, all of those things have to be working efficiently for a practice to kind of work optimally. And if any of that breaks down, it can cause a problem for everybody because they're having to do different jobs that they're not used to doing. And so if a physician has no support staff, or at least a lack of support staff, and they don't feel safe practicing, is that, kind of a reason to terminate a contract for cause? I think yes, it could be, but still got to go through the proper, provide them notice, give them the cure period, and then hopefully work out those, problems in the interim. So that's just kind of a little simple discussion on how to terminate a physician contract for cause. Hopefully that's helpful. If you have any questions, you can always give us a call at our phone number listed below in the description, or reach us through our website, ChelleLaw.com. That's CHELLE law.com. My name is Robert Chelle, and I appreciate you watching the video.